Hi and Assalamualaikum. Today, our group will present about business law group assignment. This is the question. On 1st July 2020, Melina offered to sell her blue Russian cat to Catherine at RM 7000. On 5th July 2020, Catherine rang Melina and told her that she wanted to buy the blue Russian cat at RM 5000, and Melina did not give any answer and was silent. On 7 July 2020 again, Catherine rang Melina and told her now she wanted to buy the blue Russian cat at RM 7000. But Melina told her she did not want to sell the blue Russian cat anymore to Carrie, and Carrie wanted to sue Melina in court for breach of contract. So the question asks to explain their legal right and liabilities to Melina and Catherine at law. Okay, not all agreement and promises are contract. If they are not contract, that means the people who fight under the agreement or promises made to each cannot be enforced in the court of law. Even if they will bring the case to the court would not listen to the case. It must be enforceable first. In order for the promises and agreement to be enforceable, it must fulfill 7 elements. Okay, for the first element is they must be a good, valid, enforceable and binding offer at law. Section 2A Contract Act 1950, when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the essence and that other to the act of abstention, he is said to make a proposal. Second element is that they must be a good, valid, enforceable and binding accepted at law. When the person to whom the proposal is made signifies his assent thereto, the proposal is said to have been accepted. Section 2B of the Contract Act 1950. Okay, when a proposal is accepted, so it's become an agreement or promises. Okay, the third is both offer and acceptance must be certain. Communicate subject matter also must be certain. For this point, we can relate to the case of Gantin vs. Lane 1831. Okay, Section 2H Contract Act 1950 states that a valid agreement and promises is an agreement that enforceable by law. Section 2G Contract Act 1950 said also a contract that is not enforceable by law is not a contract. Okay, for the first element, there must be a consideration to the contract in the form of money or price. And consideration is the thing of value promises to the other party in a contract in exchange for something else of value promised by the other party. This mutual exchange binds the parties together. Section 20 Contract Act 1950 states that an agreement without consideration is void while an agreement with consideration is valid. The fifth element is there must be a capacity for both parties to this contract. Refer to the ability of the parties to a contract to fully understand its term and obligation, and every person is competent to contract who is of the age of majority according to the law which he is subject, and who is of some mind and is not disqualified from contracting by any law which he is subject. Section 11. The sixth is there must be a freedom to contract. And lastly is intention to create legal system. There are cases where there were no intention to enter into legal relationship, where the agreement merely represent family arrangement, and where concessions were made in the course of business negotiation.
Alright, so in this case on 1st July 2020, in here we can state that the Melina was the offerer because she was the first who made the statement to offer to sell her Russian blue cat to the Catherine at 7,000 ringgit. So according to the Section A, Act 1950 states that when the person signifies to another his willingness to do or abstain from doing anything, with a view to attaining the essence of that order to the act of abstinence, he is said to make the proposal. The form of this offer is to sell the blue Russian cat to Catherine at 7,000 ringgit. In order to the offer to be good, valid, binding and enforceable by law, the offer must be certain and communicate. In my opinion, this offer of course has been communicated because the question doesn't say otherwise. This is according to the case of R.V. Clark. Alright, so there will be a certainty or subject matter. Regarding on this case, for this case, Marina only have one blue Russian cat, so there is no uncertainty in this case because Marina offered to sell her blue Russian cat to Catherine. And regarding on this case, in front of me, there is never say there are two different cats. Only one cat, which is a blue Russian cat. So we can safely assume that there is certainty in this case, according to the case of Ahmed Noah and Anor v. Nakoda American. In law, the person who received the offer will become the offeree. So Catherine was the offeree on 1st July 2020. Catherine was the offeree. According to the Section 2A Contract Act 1950, states that provide that when the person to whom the proposal is made signifies his assent thereto, the proposal is said to have been accepted. Proposal, when accepted, it will become a proposal. There was a good match here, and since the Catherine is the offeree, did she make any acceptance on 1st July 2020? No, she didn't make any acceptance. Anyway, there is a consideration on this case. The only thing that was missing on 1st July 2020 is the acceptance. So the acceptance was missing here because Catherine's job and obligation is to make acceptance or not to make the acceptance. But did she make any acceptance? No. Catherine doesn't make any acceptance. So there is no contract on 1st July 2020. So when there is no contract, there will be no breach of contract.
4 days later, on the 5th of July 2020, Catherine has contacted Melina and told her that she wanted to buy the blue Russian cat at the price point of 5,000 ringgit. On that particular date, Catherine has made a counter offer to the original offer made by Melina, which is on the 1st of July 2020. The counter offer destroyed the original offer made by Melina, which want to sell the cat at 7,000 ringgit. What is counter offer? Counter offer only happen when the offeree gave a different answer to the term and condition in the original offer, which is in this case on the 1st of July 2020. It's true that on the 1st of July 2020, Catherine did not say that she is willing to buy at the price point of 7,000 ringgit. Instead, Catherine said that she only want to buy at 5,000 ringgit. So the whole issue of buying at the price point of 7,000 ringgit on the 1st of July 2020 was destroyed. And in law, counter offer is not acceptable. And this particular case is same as the case of Hyde v. Vench 1840. This is just an example. If Catherine said that she wanted to buy the cat at a price point of 7,000 ringgit, then we have no problem here. Immediately, this will become a good, binding, valid and enforceable contract at law. This is because if she agreed to buy at the price point of 7,000 ringgit, it would have become an absolute acceptance. That means the acceptance must be on the same term and condition as found in the offer. For there to be a good, valid, binding and enforceable acceptance to the offer that's made by Melina on the 1st of July 2020, Catherine should have said that she agreed. But on the 5th of July 2020, when Catherine contacted Melina and said that she only would buy at the price point of 7,000 ringgit, Catherine has added a new term and condition to the original offer. When Catherine changed the original offer, this means there was no acceptance, so there was no breach of contract. According to Section A Contract Act 1950, acceptance must be absolute and unqualified. The case can be referred to the case of Hyde v. Welsh. So in conclusion, there is no contract in this case. Even if she wants to sue, she will not win the case, because how can she want to sue for breach of contract when there is no contract whatsoever? Okay, back to the case in front of me. On the 5th of July 2020, there was no good, valid, binding and enforceable acceptance by law. There was actually a counter offer made by Catherine on the 5th of July 2020, and the effect of the counter offer destroyed the original offer made by Melina on the 1st of July 2020 at the price point of 7,000 ringgit. The second effect is change the position of the offerer and the offeree. Before, Melina was the offerer, but now Catherine is the offerer, because Catherine is the only one who made the counter offer, and immediately Melina became the offeree. The job and responsible of the offeree is to make acceptance or not to make an acceptance. Was there a good contract on the 5th of 2020? No. No contract, because Melina did not give any answer and she was silent. Melina did not make any acceptance to Catherine and she was silent. Silent is not an acceptance. The leading case that silent is not acceptance is the Feldhaus v. Binti. On the 5th of July 2020, there was no valid acceptance, so there is no contract. When there is no contract, means there is no breach of contract. Okay, on the 7th of July 2020, Catherine has contacted Melina and told her that she now wanted to buy the blue Russian cat at the price point of 7,000 ringgit, but Melina had changed her mind and refused to sell it. Due to that, Catherine wanted to sue Melina for the breach of contract on the 7th of July 2020. Catherine rang Melina and she made a new offer. Catherine is the new offerer and Melina is the new offeree on the 7th of July 2020. There is no consideration to the agreement at 7,000 ringgit, even though it is not being paid yet. But in law, it is alright and there is still have element. But there is no valid contract because Melina did not make any acceptance. She was the offeree, so she should make the acceptance, but on that date she did not. Offeree has the right whether to make the acceptance or not. When she does not make any acceptance, so there is no contract. When there is no contract, there is no breach of contract. If Melina said that she agreed to make the acceptance at the price point of 7,000 ringgit, it means that it is a good contract, so there is no problem. But if she said that she agreed to sell the blue Russian cat at the price point of 7,000 ringgit on the 7th of July 2020, and after that Catherine has to bring the money in order to pay, but suddenly Melina changed her mind to do not sell the blue Russian cat, so Catherine can sue Melina for breach of contract and Catherine will win the case in court. Only if there was an acceptance from Melina, but suddenly Melina changed her mind to not sell the blue cat. Was there any acceptance made by Melina? There was no any acceptance whatsoever. So there is no contract and Catherine cannot sue Melina for breach of contract. Thank you.